Good afternoon, everyone. Thank you for joining us on behalf of the CBA Litigation Section. My name is Dave Marcus, and I'm your host for the Lunch and Learn series. We are running this throughout the year, and we'll be going all the way through October. Got a great series lined up for the rest of the year. Starting today with a presentation on the ethical implications of artificial intelligence in litigation and eDiscovery by Stephen Herrera. Stephen is a VP of Business Development at Repario, where he leads AI-driven e-discovery and litigation support strategies. He's a former environmental litigation consultant at Spencer Fane. He brings a similarly consultative approach to legal tech, blending deep legal insight with cutting-edge innovation. He is a member of the Colorado Hispanic Bar Association and serves on the Bar Association's Future of Law Committee. He's a frequent speaker about artificial intelligence and legal transformation, and he's passionate about empowering attorneys with data-driven tools for better client outcomes. Stephen, please take it away.
Well, I'm really excited to be here. Thank you all for the time. I was telling Dave before this that I was very excited and grateful that he agreed to have me on. The team's been fantastic, so I want to throw a thank you to Julian as well. I have enjoyed working with them. A little about me and my background. I feel like there's attorneys are kind of split into two camps. There's those of us that chose law school right around 6 or 12 years old, and then those of us that kind of landed there. I'm in that first camp. I went to DU for law school, took contracts with Karada and all of you DU people who know him from back when. But then kind of took a side route through practice. I have been all over the map. Was on the litigation consulting side with Spencer Fane. Got into M&A consulting and did that, which led me to an e-discovery vendor, United Lex, which is one of the larger ones in the globe. And through one of those life funny happenstances, they knew I knew enough people in the industry and had a background in e-discovery separately, and ended up joining the sales team and never looked back. But my roots and my foundation really are on the technical side. I love AI. I love looking at what's next and kind of trying to predict outcomes, especially working, like Dave said, in a consultative way with clients, kind of bringing that those early like 201 classes from law school to bear, that some of us loved and some of us hated. But it brought me here, and I've enjoyed every minute of it. The other thing that I want to add before we hop in is I love interruptions more than anything. Please, as Dave said, please throw those questions in the chat. The more this turns into a conversation, the more I feel like we're all walking away better prepared to tackle what's next. So please don't hesitate to throw them in there, and let's chat about them and make sure that we walk away with clarity. Today, just wanted to dive into AI, especially as it relates to ethics. This is a complicated area. I feel like all see probably two big headlines each day. One is a new sanction for a law firm or an attorney who mishandled AI. And another one is a partner getting an award for saving their clients millions of dollars in damages, etc. And landing in the right camp is a difficult matter, but one that I feel like is not just important for our reputations, but also for our clients, because it impacts from the beginning of the stream of their understanding of us as attorneys all the way straight through to billing and accounts receivable. It's an interesting world, and one that matters to get right and make sure we understand our place within. Little agenda for us to walk through. I want to start with the learning objectives and then start with where AI is now. I think there's a lot of misconception about what AI is and isn't, what it can and can't do. Get into the practical application for yourselves as attorneys and what the transformation process looks like for, let's say, a law firm, corporate legal department, and then moving into what AI's role is, what you need to keep in mind in using it, and the more strict rules that govern usage for attorneys in Colorado. Lastly, best practices. I want to talk about due diligence. These are things that come in as the hard and fast rules, as well as our continuing education, making sure that we're not only staying on the right side of the rules, but effectively using the tools at our disposal. I still, since kind of the beginning, I've really likened it to the moving from the abacus to the calculator. Each of these pieces come together in a unique way that I don't think either A, have to completely redefine our profession, but at the same time, I don't feel like we get to ignore them because they do enable us to become better advocates. So learning how to harness it, but maybe even more importantly, when to harness it, is critical for understanding how our opponents are going to be thinking, what our clients need, and largely how the court system is going to be working. And some of that is simply on a state by state basis. I want to make sure that we walk away, and Dave, I'm going to ask you to hold me to this, with a strong understanding of the ethical considerations, what you do and do not need to keep in mind in a hard and fast way, the impact on your rules for confidentiality, competency, and diligence, and the different AI tools available from a broad spectrum. I'm not going to try and dive into any of them on a micro basis, but help you understand where you can be using them, how you can be leveraging them, the risks of generative AI in litigation generally, and then the effectiveness of methods that we already have over AI and with AI. And that should give us kind of a pretty good picture of where things are at now. I want to start with a little frame shot of where we sit today. Obviously, it's changing large areas like legal research, contract analysis, and eDiscovery. I sit around all three of those, so that's kind of my day-to-day is walking clients through those. The last, let's say, 15 years has been spent around things in the ballpark of what we call TAR 2.0, and the litigators will, a lot of them will know that term, of tech assisted review. So many things, we moved from a lot of paperwork, whether that be contracts moving into CLM, paper moving into eDiscovery, and legal research moving from law libraries into Westlaw, as an example. The same thing is starting to happen with AI, where we're seeing a lot of tasks as opposed to, say, storage systems being revitalized and kind of evolving within the space. As kind of sticking with that law library example, we saw a physical and storage mentality shift, going from paper, going into the law library and literally pulling up the physical books, to resources. Let's switch and let's even use LexisNexis, where you can search databases, extract key terms, and then do the reading from there, so that you're only going to that two-page infrastructure that you need to find the answers you're looking for. We're now moving from kind of a hosting revitalization to an information understanding shift, and that's where terms like NLP, natural language processing, and large language models, LLMs, that's really moving us into not just how do we get to the page we're looking at, but how do we use tools to extract concepts from the pages that we're looking at. And that's where attorneys, I feel like, can most effectively leverage the tools at their disposal without getting outside of the bumpers. They can get into, let's use the example of a large data set, middle of litigation, and we have like 50 people's email inboxes that we need to get through. The shift from paper to digital allows us all to host that in one single repository. Now with AI, the beautiful thing that we're seeing is the ability to parse through it and extract concepts. A did email B at a low level, but also A intended to communicate X to B at a higher level. But then sitting on top of all of that new capability are the ethical considerations. And that's where professional rules of responsibility and staying up on our CLEs is incredibly important. So a big part of this, as some practical applications, legal research, I think we kind of touched on that one, but I want to talk about contract analysis as well. You'll probably be seeing a lot of, and this isn't really my sales area, but this is one where a lot of clients dip in, is contract analysis. As these LLMs get better, basically what they're doing is they're reviewing contracts that you and the wide berth of attorneys have reviewed in the past, extracting patterns, because it still is simply ones and zeros, and seeing how and when previous attorneys have made certain contracting decisions, be that all the way from a red line to specific comments given, changes requested, and it logs, categorizes, and catalogs those changes made by attorneys to understand conceptually, these kinds of red lines are considered acceptable in these kinds of cases, these are standard form, and this third camp are ones that are traditionally pushed back on. The beautiful thing about that is it allows attorneys to take large contract sets and not just move into that contract management space, but review them intelligently. But again, naturally, the second piece comes in with we have to look at the potential risks and compliance issues. If you are a contracts attorney in the state of Colorado, that doesn't just mean looking at the effectiveness of the tool and whether it's a well-regarded tool. That also means that you need to make sure that you're reviewing the work done by the AIPs. eDiscovery, a little closer to home for me. We can use this in document review across large litigation sets, but our responsibility to confirm the value and the credibility of the work that's being done still sits with the attorney. So these are some of the ways where we see it advancing, but making sure that we're understanding the base layer and not necessarily like the technical pieces of how the LLM operates, but how and why it makes certain decisions is important for keeping on top of our ethical responsibilities. Um, the three pieces I kind of want to touch here are the ways that we can use these tools and make sure that we have a good understanding of how to direct paralegals and other employees in using the space. So let's use legal research and analysis as an example. We can use, let's say, sometimes a paralegal, and when I was a paralegal, would be assigned certain research responsibilities. We can now leverage tools. Let's use ChatGPT as an example. However, we still have, let's even use confidentiality as an example. We need to make sure that in legal research and analysis, we're examining license structures. That can mean if you have a ChatGPT free license, everything you're putting in for the LLM to run against is public and can be used not only for training data sets, but you can view other people's chat histories. So putting in scrubbed data is one of those things in the middle line, but putting in client names, plaintiff data, et cetera, straight into LLMs like those is where you can get into a little more trouble. Same thing as a broader understanding of machine learning and NLP tools. We can use those to predict case outcomes. Absolutely legitimate way to leverage an LLM for your benefit in a legal case. But also at the flip side of that is analyzing how much we're putting into automated tasks without eyes on review. And that's one of the big cost centers of AI-led review is there's the two sides of the coin of courts allowing it to occur more and more, but also the court's rulings on the subject still require eyes on QC or quality control. So going through these automated tasks, however you choose to leverage it, is still going to require attorney time. So learning to leverage the amount of QC required against the value of the tool is important. And keeping all of that in mind with your vigilance, I think that's really the phrase that comes to mind is attorney vigilance. It's not that any one tool is wholesale bad or wholesale good. I think it's just always a degree of levers that you're pulling to make sure that you have an adequate understanding of what your client data will be touching, where it will be going, and how that's being used, and making sure you're responsibly checking everything that's done. I think predictive analytics is a great example here, and we'll use an eDiscovery framework for this part of the conversation. There are cloud-based solutions. We don't own it, but we use it. Everlaw being an example that a lot of Colorado attorneys use, and I know is used in Colorado government AG office, et cetera. There's vendors, and we'll use them as an example, that have internal technicians and local groups that you can partner with. And let's say predictive analytics is an example. I wouldn't say that the average 3 to 5 person law firm either has the manpower nor necessarily the capability and thus the requirement to stay on top of every single technical piece of how these are developing. And the thing that comes alongside that is then instead of bringing on or hiring a person dedicated to, let's say, lit support or an IT manager that has an in-depth understanding of these things, the capabilities that we have to make sure that we're staying in the know can rest with partners. My bent is always going to be vendors, but there's also technicians that are available through local groups and local affinity groups. eDiscovery is an example. Colorado has local eDiscovery groups. They have CLM groups. It doesn't have to touch any specific area. And through those, you can still maintain, be it through CLEs, local talks, chapter meetings, an up-to-date status on the state of the technology so that you're making informed decisions and strategizing effectively. Now, using this for decision making is where things get a little complicated. And I think it's probably the area that attorneys need to have the closest eyes on, maybe tied with uh, monitoring what systems you give privileged client information to. Relying solely on AI for decision making is a bit of a risky task to undertake. Candidly, it gets a little easier with the increase in size and organization. So the larger the law firm, not necessarily the better they are at it, but the greater the capability to stay on top of this because of the overhead that gets attached to that, IT teams, paralegals, etc., that are able to put a second pair of eyes. I would encourage the smaller law firms to be careful how they do this, because that's how you can kind of get slapped with some of those reprimands, is when you're allowing, let's say, Copilot or ChatGPT to provide certain legal analysis. And there are points where you should double check that, or even just run to Westlaw to confirm the information you're getting is valid and useful. I think it's where we can really work as a unit within a firm, and have paralegals that are constantly learning how to attack certain pieces of information, double check sources. It's a reason that I do recommend to a lot of law firms actually Copilot over ChatGPT. I do find that Copilot, I won't say it's more reliable in the information it returns or has a lower hallucination rate. I will, however, say that Copilot's footnote function is pretty solid. That is probably the only tool exclusivity push I would give. And it's a pretty simple way to double check the information it's giving you. And kind of the actionable step for this is to cross-reference the work you're already doing. I would say that the firms in the corporate legal departments and government groups that are not yet fully baked into AI are maybe in the best position. And I'm probably one of the only people that would say that. But I really do believe it's true, because it's an interesting crossroads where you can examine the way you're doing work now, and create a roadmap for growth. I feel like it's the firms that dove in headfirst into a full AI workflow for all of their projects, that can have a harder time backing up a little bit and connecting it to what they were doing before. But to whatever extent you're able to take a moment and look at how let's stick with legal research, how you're conducting legal research today, and connect two things: one, the end goal you're trying to achieve, and two, the responsibilities and even the marketing level promises you've made to your clients. We could call them mission and value and vision of your firm or legal group. Taking those two camps of concepts and letting that be kind of the rubric by which you judge where to let AI into the process and where not, can save a lot of the problems that I'll frankly say a lot of large law firms have gotten into, because there is a pressure today. The larger the law firm, the more I've seen this, to be showing high-end partners a certain degree of AI use. And that's not in and of itself bad. But I do believe the point where IT teams and lit support groups are being pushed, and paralegals are being pushed to use this before a POC, is where firms can get in a lot of trouble, especially when InfoSec teams aren't consulted. And that's where, on a large scale law firm, we can see the more serious issues and the more serious infractions that we see on Law 360, et cetera. So taking those moments and those opportunities to consult as a group about where you've been, what is core to your legal group, and letting that be the filter that judges what passes through into a new process, I do believe can be incredibly helpful. I wanted to pause here. Like I said, I love kind of letting these become conversations. If there are any questions, kind of a natural pause point. But if not, we can also continue. Going once, going twice. Dave, unless if there was something else to add, I'll keep pushing through here.
Your show, Steve.
Um,
Take it away.
so let's talk about the hard rules. Starting with competence. I'm even just part of the CLE going to read these out. Attorneys must understand the technology they use, recognize AI's limitations, and ensure proper training to avoid missing relevant documents. Staying informed about AI developments and consulting with technology experts is essential. And this is obviously the connection to the rule, not the text of the rule. For confidentiality, attorneys must protect client data even when using AI tools. Generative AI platforms store inputs, posing data security risks, and cloud-based AI tools must comply with data protection regulations. Conducting due diligence on AI vendors and implementing security measures like data anonymization are crucial. And lastly, on diligence, attorneys must exercise thoroughness and promptness in AI and eDiscovery tasks. This involves conducting a risk-benefit analysis before adopting any AI tool, consulting IT and compliance teams, and regularly auditing AI-generated work. So starting with competence, as kind of an overhead and an asterisk that I like to give here first, I think there's 2 points that I think attorneys can take practically out of this slide, and it's kind of the unknown facets of the limitations and the risk associated with AI. And the first one is simply the cost of the tool. I do feel like this is important internally. This is sorry, I'm seeing some questions here. Oh, not questions. Yeah. The cost of the tool, and I think this is important for plaintiffs groups as well, even though they're not necessarily passing through the cost, though they often are. The cost of the tool can really impact the ability of a legal group to proceed through work. And that's not just the software cost. So many groups work and softwares work, especially on an AI basis, through the number of questions that you put through. Let's say, for example, you have large scale litigation and you want to ask questions against the data set because you've seen so many attorneys do this and you've seen it on demos. I would say conservatively that probably 95% of work that gets put through AI and software is you are charged per question you ask. And the interesting thing is usually you'll get the cost against the body of the data set that you're asking against. So let's say the Enron data set at its largest, this is a massive data set. And if you are charged for every gigabyte of data or document, even whichever, that you're asking it against, it might be incredibly effective at answering the question. But one, you have to bear in mind that you've asked one question and you're being billed not by the number of characters in your question, not by the length of your question, but by the size of the data set you're requesting it against, because LLMs, large language models, are the easiest way to understand it is these machine groups are built around ingesting the full breadth of the information, categorizing all of it, understanding all of it, and then returning information. So conceptually, the best way to understand it is you've asked someone to memorize all this information, understand it conceptually. And every time you ask them a question, they're not just taking the concepts they've gotten out of it. They are, in a sense, asking that question and then back playing telephone against the full data set that you've put in there. So if you're asking against, say, an Enron data set about the CEO's communications with the CFO around the long-term financial viability of the company, it's not just going to magically go find those 3 documents that are important. It's going to ask it against the entire data set. So this is where understanding how to layer different tools and layer different technologies is incredibly important, because otherwise you can find yourself drowning within helpful answers and a high AI bill. So the cost, while we often talk about the literal upfront cost of AI, using it on cases especially, I do think is something to keep in mind and make sure that you're responsibly portraying to the client. And I saw one question, and I feel like it ties into this. What do you feel are some of the pros and cons of allowing AI-generated witnesses in a courtroom? I did see the case. There have been 2 that kind of crossed my desk. The one last week, I believe it was Arizona. Very unfortunate example where a man was killed in a car wreck. And the family created an AI generated video statement by him. Incredibly powerful testimony. Oh, and David, you actually included it. Thank you. It's I believe it's incredibly powerful. I probably won't speak on it from an ethics standpoint simply because that's not my area of expertise. It's very doable, and I would say it's very affordable. So if you feel like your local and state rules allow for it, incredibly powerful testimony. I mean, I think most people I know saw that on LinkedIn. It's pretty moving. And allows for a gap maybe in the justice system that I think we could push through as an ethical consideration for allowing that kind of testimony, because when someone passes or becomes incapacitated and is unable to testify on their own behalf, there is a limitation to justice that occurs there, and there is a natural gap. And I do think where we can bridge that with technology and allow for someone's case to be communicated with some of the emotional weight that would have otherwise been there had they been in the room and been able to share their experience. As long as it's done within the bounds of truth, I do believe it's effective, and I would personally probably be in favor of that kind of use of the technology. And I saw your note, Ruth. I will make sure that I'm interluding the full names. I've been trying there with the different AI tools and the acronyms we have for those. But the second piece that I wanted to include in competence is not just knowing and understanding the end cost of tools, not just the upfront cost, but also how this will affect your time use and billable hours. I think there's a lot of misconceptions that AI will automatically reduce AI attorney time spent. I think that entirely is dependent on the ability and understanding of the attorney and their understanding of each tool and where it's used. I think probably the easiest entry point for that is AI legal research. I don't think there's going to be a lot of time lost in leveraging it there. I do think in litigation is where we see the flip side of that, where a lack of AI competence can not just turn a case upside down in terms of cost spent, dollars spent, but in attorney time spent, where especially if we have fast moving litigation with short discovery deadlines and short production deadlines, that's where not only we're seeing high billable time in trying to fix issues that were created through a lack of understanding and competence around AI, but also case strategy kind of goes underwater. If you put all your eggs in that basket and it doesn't pan out, then you're left with a lot less room to maneuver in effectively advancing your case. Number two is confidentiality. Like I said earlier, I think this is incredibly, incredibly important, probably paired in most importance on, or highest importance as far as what I would recommend to Colorado attorneys. I've run into so many people that will put incredibly confidential information into ChatGPT. Now, if this is your own medical records and you would like to put your own data in there, I'm going to probably share an unpopular opinion, and that I tend to feel like most data is simply lost in the noise. There are simply so many requests going into ChatGPT. I won't call it safe, but there's simply so many requests going to ChatGPT on a daily basis. I wouldn't ever really think that someone putting in a health request or a question treating ChatGPT as a doctor is something that your colleagues are going to run across or anything like that. I feel like the problem area is the present minimal but still present risk of financial data and the kind of data that can really upend your life, but equally important client data. There are a lot of attorneys putting in client names, personal health information, personal identifying information that they've been given in their role, exclusively in their role as attorneys, that they wouldn't have access to otherwise. And this is where there can be a lot of problems coming up. And simply using, I think it requires a lot of examination of your own practices, but also state by state rules. I don't believe that the ChatGPT Pro, for example, version, where you have the opportunity to create a temporary chat that you can see up in the top right, and they say they'll only keep it for 24 hours. Really understanding Colorado, especially Colorado's rules around data, We're a little closer to the UK than, let's say, Arkansas as far as our data rules. Um, how we're housing data, where we're putting it, and where we're giving it access. It's often where there's an access to data that matters more than where it's housed. Um, so you could say that by putting it in ChatGPT in the temporary chat function, it's going to get deleted within 24 hours. But in doing so, you've allowed it to leave your system. So in the same way that emailing private client data to your personal email that 7 other people have access to, it's simply the fact that access has changed, and ChatGPT, the group, has access to that information, is where you can get into a little more trouble. So there's kind of 2 layers to protection there. One is data scrubbing, which is probably the most popular, where people will go ahead and put their prompt into ChatGPT or whatever LLM you're using, large language model you're using, and they'll scrub data. Let's say instead of John Adams as plaintiff A committed A, they'll say XY in case BCD did X, and they'll leave the case facts sometimes. This is probably what I call the gray area and the unrecommended. It can be incredibly effective, and it can be safe if you are completely scrubbing data and it is unrecognizable. But I think this is where we could kind of use the analogy of writing out case notes on a post-it. The line from where it is unrecognizable to anyone's eyes to where certain people could start to put the information points together and have you have breached confidentiality rules is wide, and I would say very gray. So in the same way that we probably wouldn't want our doctors putting our initials, sensitive health information on a post-it and leaving it places, the same kind of concept applies. Really understanding the rule, but also where you sit and where you're putting the data, especially as data becomes more voluminous and easier to access by outside groups, the responsibility just gets more important. The same is true for whether you're using cloud-based or on-premise solutions. For those of you that are in contracts, Evisort is an example of a cloud-based solution. Contra and RazorSign are on-prem solutions. Basically, all you need to know about that is when it's cloud-based, it means it's being stored elsewhere. So you're responsible for the literal access to your computer and someone getting into that. But if it gets hacked, that's a little bit outside of your control, as long as you've been careful in choosing who you work with and what software you work with. On the flip side, let's say you're working with Relativity on-premise or Contra or RazorSign on-premise. That is solely within your system, and that's where it becomes more your responsibility to have a firewall, but also to, those the trainings we all love once a year. Lock your machine, make sure you don't have your password out, making sure that you're keeping the data housed in a responsible way, but also in a safe way, kind of moves closer and closer to your nexus of control. So it becomes closer and closer to your area of risk and risk threshold. Then third, I'll kind of camp this under supervision and non-lawyer assistance. In the same way that when I was a paralegal and I was tasked with legal research and creating a memo, the degree to which that was relied upon by the attorney was kind of scaled against how much supervision I received. Attorneys are ultimately responsible for the work product and the work being done. And the degree to which we rely on really practically any work other than our own brings the not the risk, but the weight of responsibility back towards us. And this is where that earlier example of kind of moving from abacus to calculator to LLM works pretty well. Whether you were using an abacus or a calculator to do a damages calculation, let's say, it was all within your control. It was all data you were keeping in front of you, and it was all ultimately being done by you. The more we move into these advanced tools, the further the data moves from us and the less control we have over the output, the more eyes on we need to kind of compensate for that distance. The less the work's being done by us in a purely factually reliable way. I don't think many people are suing over a calculator mistake so much as a lawyer's mistake in inputting into a calculator. But when we see terms like hallucination, where large language models like ChatGPT return completely false information. I do feel like hallucination rates are a little overstated, but I don't think the responsibility to compensate for them is overstated. I can't tell you the number of times that I've done case research and I will have started a query in ChatGPT and gotten completely false results. Now, never relying on that so it doesn't turn into a problem. And the majority of the time in which it does function correctly, I have saved time. But when I'm putting in queries and I'm not supervising not only the work but the results and making sure that I'm double checking it against something, it's the same as if you gave it to a legal intern. Let's say you have a college poli-sci major like I was that came in to do free legal research and just kind of clerk around the office. Farming out work to them is fine, but the less experience they have and the more unreliable the results, the greater your responsibility to check into the work they're doing, make sure that, especially if you're relying on it for client output, using it in trial, using it for client recommendations for how to settle a suit. I think that combination is important, but also is where pointing fingers can kind of become an instinctive reaction. And I don't believe that that is an excuse that right now the courts have any tolerance for. In the same way that you couldn't blame it on the college kid that came in to help, you can't really blame it on ChatGPT. And I feel like, if nothing else, courts are getting a little trigger happy about issuing sanctions and warnings for that with the climate that we're in. Julie Walker, that is a fantastic question. Am I aware of any ethics opinions that discuss the attorney's duty to disclose use of AI to clients? I'm going to refrain from looking that up on ChatGPT. I will research it later. There are a couple that have come up. I would say there's two big questions that come up there. I don't think that the majority do disclose AI use in the same way that when I went into the urgent care 2 weeks ago for an asthma thing, the doctor is using AI over there, and we see that in a lot of cases. It doesn't always have to be disclosed, but I think it's on a couple of different, it's always on factors. The way in which it's being used and how it's being used in decision making, what kind of decision making, is probably a bit of a rabbit hole I won't go into. But I would caution that it mostly relates to malfeasance, so I would always recommend it. And I think there's a way always to turn it into an upside for marketing. I think that law firms especially have an edge these days when they have some kind of promotional materials around AI. So you can kind of combine, frankly, your disclosure of AI and kind of a value upsell. And I think that's a responsible way to tackle the issue and make sure that you're sharing how what kind of work you're doing at the front end. And again, what you're doing with it is always incredibly important. I don't know that I would ever disclose that I was using it for double checking spelling. But I think there's another end of that spectrum where certain ABA decisions have come down that would tie in closer to that. So best practices and ethical guidelines. Some practical recommendations would start with conducting a risk-benefit analysis before adopting any AI tool. Ironically, a lot of groups use ChatGPT to do exactly this, because you can leverage large language models to kind of do some risk analysis, which I think ties into a bigger picture of understanding, and this is kind of the niche term of the day in the last couple months, prompt engineering and effective prompt engineering. It's something that attorneys more and more are going to be required to do. If you're in the litigation space and work in eDiscovery tools, you're often going to be asked to do certain searches against data sets to find these quote unquote smoking gun. That is changing with AI. If you choose an AI tool for litigation and eDiscovery, for example, you're going to be searching in a completely different way. We used to call it Boolean search terms, kind of the technical version if you've gotten into like technical Google searching, the and, the or, the different options so that you can return only specific data results. The same is true here, but it's completely different. Attorneys are going to need to learn to search differently and ask questions differently of AI if they're going to be using it. So recognizing its limits and the ways that maybe sometimes the current work that you're doing maybe even outweighs and is more effective than AI could be in that scenario. I think that is generally true. It's not a popular opinion, but I do believe it's backed up by most of our data engineers across the space. That, for example, AI and eDiscovery isn't necessarily the best way to proceed as a use only tool. It's really best layered at this point. But I think the same thing happens with due diligence on the AI side, making sure that you've worked with your IT team, your paralegals, understanding what your current process is and what that evolves into. Because if you don't have all of those lined up, pretty quickly, confidential client information can inadvertently end up there, especially if you're aware of the ethical rules around AI, but haven't informed your paralegals, interns, law clerks, etc., and they don't know that it's not fine to throw it in. I think CLEs are incredibly important for that, staying updated. Local, again, like I said earlier, affinity groups, I think can really help sharpen your understanding, keep you aware of where the limits are in your state at any given time, and also help you speak to clients. Like, let's say you are using AI within your office, you can more effectively coach them through how it'll work. Like I said earlier, I always recommend sharing because I do believe it can be helpful in them understanding the costs and how you're better advocating for them. But it can also, like I said earlier, become an upsell. And working with AI experts to make sure you understand and can explain things well really helps bridge that gap. And also just understanding the consequences of AI misuse. The fees can get painful, but I do believe the hit to reputation these days is what's hitting the hardest. I would probably rather receive an X dollar fine than become the face of LinkedIn for 2 days. I don't think anyone has forgotten the cat Zoom lawyer who, if we remember the story, it was actually used by someone in his office earlier who had turned on the filter. So he joins the meeting and doesn't know, hadn't turned it on himself. So those consequences, even if they seem out of our control, kind of can feel less and less in our control with AI, especially the further we are removed from the information around how it works. So the two biggest things that I would say kind of tie into that same thought, consulting, I feel like is the simplest and easiest way to not just shift risk, but to remove risk and centers of risk. And there are IT teams that will do that at a low cost. Whatever vendors you work with, whether it be for a CLM or otherwise, contract legal management software, you can talk with them, speak with them, and better understand what they would see as you, not just your requirements, but the ways that you can effectively use AI. I think the beautiful thing about ethics is it also, I believe, can make us more effective. It's not just the boundary lines we have to stay in so we don't get in trouble, but it also helps us, I believe, return to the core of who attorneys are meant to be as advocates. And in really understanding the philosophical and advocacy reasons why they are there, help us, I would say, better perform and better serve clients at the end of the day. And then the last thing is engaging. I feel like LinkedIn is also probably an unrecognized place for this. There are lots of AI groups and legal AI groups on LinkedIn where blogging in once a day and reading 2 or 3 posts can really give you some material, not just to share with your clients, but to expand your own understanding, see what court opinions are coming down. I know the talk groups in there are constantly updating on ABA opinions, state bar opinions on these, so that you're kind of the first to know. because it can be difficult when there isn't a singular news source for these things, to make sure you're catching them as they come in, especially handling 99% of the work being client work. Staying on top of this can be an extra piece. So leaning on things like that, I would say, is not just helpful, but important. So kind of broad takeaways, AI is powerful, useful. I love the example earlier of using it for testimony. I think the applications that we haven't tapped into are more exciting than the ones that are broadly being used. But just making sure that you understand your responsibilities. Again, the kind of pairing of how to use effectively and responsibly, and making sure that kind of the boring thing, but the client data is in a safe place, are the two easiest pathways to that. And finally, understanding AI's limitations. I think knowing what it is and what it isn't, how often and what kind of questions it will return with higher hallucination rates or mistakes. Just understanding those things and getting a grasp on that can really help you not just leverage it for your use and get a benefit out of it, but protect your clients in the long run. That is the bulk of what I had. I enjoyed the time with everyone, and thank you for the questions. I'd love to hop into some more with what questions people have.
Steve and I've been kind of trying to help you address the questions in the chat a little bit with some of the ethics opinions questions that have been coming up there. Can you help by telling people what they should be looking for when they're looking through, for example, the privacy policies of an AI tool, and kind
Yeah.
of give them some hints about that?
Yeah, that's a fantastic question. Kind of the easiest hack to that, in my opinion, is less about knowing if, let's say, Claude 2.0 is going to be sending it to this state, this region, this country, sharing it with this affiliate. Unless if you're part of a large organization, frankly, unless if you are explicitly told that the data will not leave your environment, I feel like the safest policy is to assume it will be accessible and therefore no longer confidential. And the same, and people really do treat AI as kind of an exception to the general rules. When you're doing privileged work, it's usually on, your Microsoft Word platform. It's being done in your PowerPoint. It's being done, if you're in Relativity, it's being done on-prem often. It's never leaving your IT space. It's never going out anywhere. And I feel like people have kind of forgotten that 99% of the work that's done stays in the office and never technically leaves. So I feel like people often expect a bit of an exception to be made for AI, and it's simply not there, in my opinion. The conservative approach simply is to assume that unless if you're explicitly told, like let's say with a my Microsoft 365 Copilot premium license, which I believe is about $20 a month, and set up as such, unless if you are explicitly told this stays in your house, you simply can't assume that it is still considered confidential. In the same way that I wouldn't consider a Microsoft Word document that you give access to an outside group to read through completely, I would no longer consider that confidential. I think people hear that it is technology, so they don't feel like they're sharing it with another person. But the reality is that the vast majority of the time, you're technically sharing it with the world, because these large language models are trained on every question you ask them. And this is probably where my law school training comes in, and also my work comes in, is I would not treat those as confidential. But I did see a tie-in question from Maddie Moore on what's your opinion on using a paid model like Claude Enterprise, ChatGPT, Teams accounts on client medical records that contain PHI. These companies stated that they do not train on your data, have SOC 2 and other security measures in place, but unless you use their API, they are not HIPAA compliant. A lot of different opinions across firms. I really sit at the conservative end of this, and what's interesting is a lot of litigators will have either used or touched Relativity. I think it's a great example. They have a product called Relativity Air that is a large language model that you can ask questions about large data sets. What most people don't quite realize yet, in using that as an example, people that use relativity, is they're using ChatGPT. 99.9% of these large language models are APIs connected to ChatGPT. They simply are kind of like the center of AI right now. So it's all about, and I think that's an excellent point, saying that they state explicitly, and it is explicit, that they don't train on your data. And that's the temporary chat piece that I was speaking to. I have a license where I can create temporary chats where it won't be trained on and it's deleted within 24 hours. And this is where that access piece comes in. Is the PHI is leaving your environment and going there, so it's accessible. Just as a matter of fact, at OpenAI, as my understanding is that they can a tech can go in. I think we've seen this in complaints with Tesla, Twitter, iPhone, where they have allegations of listening to users. The same is true here. Just because they're not supposed to train their data on it or keep it doesn't mean they don't have the ability to. And our responsibility for confidentiality is more centered around what's possible than what's supposed to happen. So even if I create an agreement of confidentiality, I'm still required to make sure that that holds firm and is reliable. And I think courts just don't see it that way with the enterprise versions of these LLMs. The only one I would do that personally with is 365, and that's only because it can be set up to stay within your environment.
Stephen, Julie had a question, and then there are a couple more in there as well from Ruth. But Julie had a question about ethics opinions about disclosure of AI use to clients within engagement agreements. And we answered some of that in there, but what about disclosure requirements for courts themselves?
Oh, that is a fantastic question, and I always prefer to share my ignorance where I have it. That is an excellent question, and I don't know where. I haven't seen anything from Colorado about that. I do believe that if I remember, and I'm trying to be conservative here, I do believe that if you're using it for, and I'll stick to eDiscovery and eDiscovery as an example, because that's where usually the courts are going to become involved, is in the litigation space. In the same way that eDiscovery, through the likes of people like Judge Peck, progressively became more acceptable and court friendly. AI is the same way. I would not recommend using AI against large data sets and not disclosing that. I think that's part of the discovery rules, meet and confer, those initial scheduling conferences, is usually you're agreeing on set key search terms and production values. And I don't feel like it would be possible to responsibly participate in those conferences through Rule 16, et cetera, without disclosing that you're using AI. It would and should naturally come out. Oh, I think I'm at least not able to hear you. Sorry, I don't know if.
Dave, it looks like your audio isn't working.
I was so afraid that was only me.
That was weird. It was working a second ago. So hold on,
That is
let him
odd.
unplug and plug back
While
in.
he's resetting, I can head to the. Oh, sorry, I didn't mean to cut you off.
No, you're fine.
I can head to the next question from Ruth Moore. It seems that parties use AI to search their own data and public data, but then act as though they are stuck in the electronic search models of 20 years ago when propounding discovery demands to each other and negotiating search terms. Are any lawyers already using large language models to search others' data as some sort of alternative? Absolutely. That's something I work with DSARs with some of my UK clients. There are certain ways to leverage AI, and I think a lot of people assume that it's not useful just because you're receiving data as opposed to producing data. It is absolutely useful for that. The thing that I would always recommend doesn't have to be me, partner with a vendor because I would say it is complicated to do it in a cost-effective way. I recommend these days that people layer tech-assisted review, where you're doing kind of the keyword searching, where you can remove a lot of the fluff data, and then apply generative AI for AI questions asking against the data set. Because then you're down to, let's say, like 1,000, 2,000 docs, and you can ask it broader conceptual questions, absolutely, of opposing parties' data. Once they've produced it, it's yours. Again, doing that within an environment in which it is safe. I would say Relativity and Everlaw being the two great examples of that. Is absolutely feasible. I would say that that can be incredibly cost effective. I've brought that to bear in litigation for clients, saved, frankly, a lot of money doing it that way. And I think working with a vendor can help you keep the costs low, as long as they're not exorbitant in their human time cost. Then I saw another one come in. I hope we still have Dave here. Judge Cruz has a rule that any motion filed must disclose no AI was used.
Yeah, so
I hadn't seen that.
Can you hear me now, Stephen? Am I working?
Yeah, I can hear you now.
Great. So I was going to bring up Julie's comment there, and that seems to be the general practice across courts. There aren't any standing rules from chief judges necessarily, or there may be some that I'm not aware of, but it's usually a local order, with a specific judge.
Yeah.
Judge Cruz has one. There are a bunch of judges down in Texas, I know, that have some. So I think the advice would be to check the standing orders of the court in which you're practicing, in order to find out whether you have to disclose AI rules or not.
Yeah, and to the court, I always absolutely would. To clients, what I was speaking to earlier, I feel like it's like a more gray area, but I don't think I've had a single client use Gen AI on a case and not. I don't see the purpose in not disclosing that, especially because those Rule 16, or the discovery conferences broadly, it will naturally come out. And if there are any questions about your productions, that will immediately come out. So in litigation, that is one of the first things I would do. And I see it as acceptable that as long as it's with a reputable tool, I haven't really seen issues around it. So I would simply recommend it at the front end. And that is fantastic to know on the local side. I think we'll see a lot more of that.
Any other questions that we have for Stephen while we have him available? That looks like a no. So, Stephen, thank you so much for your presentation. I don't know if you have if you want to put your email address in the chat. If you feel comfortable, we'll reach out to you with any questions that you have there. There we go.
Please. Except
you didn't update it with your actual data.
I was hiding that slide before you could see it, Dave.
That's okay. If you want to throw it in the chat, that's great. If not, there we go. So thanks everyone for joining us on our monthly Lunch and Learn series. Next month, we're going to have a great presentation from Elizabeth Horton from DGS, Davis Graham Stubbs. I think, if I'm looking at it correctly, that will be on the 25th of June, which is also Bike to Work Day. So if you guys have a bike and you feel like biking to work, I know they'll have free breakfast burritos and coffee out there at various stations. And if you look at my LinkedIn, I have a post about that. She's going to be doing a presentation on active listening and how that can help you in litigation situations. So, Stephen, thanks again. And we look forward to seeing all of you next month.
Thank you all. Appreciate the time.